Payback times.
The mist came off the cornfields the same way it always had, low and deliberate, rolling across the rows like something that belonged there. I stood on the back porch of my father's house, with my coffee going cold in my hand, watching it move. The frost had come early this year, silvering the dead stalks my father never got around to harvesting before his heart gave out in August, and the morning was the kind of quiet that only exists in places where people have been working land long enough for the land to remember them. I was thinking about my grandfather. Desmond Achebe-Wilder had cleared this eastern tract by hand in 1951. Not metaphorically, the man had taken an axe and his two oldest sons and spent the better part of 3 summers pulling stumps and hauling limestone out of 40 acres of Harlan County hardwood. I had heard the story so many times growing up that I could still hear my father's voice telling it. The particular way he said the word stumps, like it contained the whole weight of the labor. My grandfather never finished high school. He could read a deed, though, and he understood that land was the only argument that lasted. 30 years of practicing property law had not changed my mind about that. The phone rang at 6:47. I know the time because I looked at it. The reflex of a man who spent 3 decades in courtrooms where timestamps mattered. Unknown number, local area code. I almost let it go. But something in the quality of the morning, some barely perceptible shift in the silence, made me answer. Mr. Achebe-Wilder? The voice was young, female, cautious in the way that people sound when they have been tasked with delivering uncomfortable news to a stranger. This is Brenda Oakes calling from the Harlan County Clerk's office. I'm sorry to bother you this early. I wanted to reach you before the office got busy. A pause. Papers shuffling. We have had a filing come through. A notice of adverse possession claim. It has been filed against parcel 14A of the Achebe-Wilder estate, the eastern tract, 40 acres, bordering Pruitt Creek. Another pause. Shorter. The name on the filing is Clifton Pruitt. I set my coffee down on the porch railing. The mist was still moving across the cornfields. A crow landed on a fence post at the edge of the yard and sat there like punctuation. Mr. Achebe-Wilder? I heard you. My voice came out even. I felt my jaw tighten, the muscles along the hinge doing the work that my face was not. When was the filing received? 3 days ago. We send written notice to the estate address, but given the circumstances, with your father recently, I wanted to make sure someone actually got the call. I appreciate that. I will be in this morning to pull the documents. Of course, we open at 8. Thank you, Brenda. I ended the call. I stood there for another minute, looking at the frost on the dead corn rows. Clifton Pruitt. I had not heard that name spoken aloud in over 20 years, though I had seen it once or twice in that peripheral way you notice the names of people you have deliberately stopped thinking about. He was a second cousin, distant in both blood and character, the product of a branch of the family that had broken away sometime in the 1970s over a property dispute. Not this property, but a different one, and the details had always been murky in the way that old family grievances tend to get. My father had spoken of him twice in my adult memory, both times briefly, both times in the past tense, as if Clifton Pruitt were something that had already concluded. My father's obituary had run in the Harlan County Courier 4 weeks ago. I picked up my coffee. It was cold. I drank it anyway, because I was already thinking, and thinking required something to do with my hands. I knew what adverse possession was. I had spent 30 years watching it work on both ends, representing families who had lost strips of land to encroaching neighbors, and defending clients who had, through one combination of circumstances or another, found themselves occupying ground they did not technically own. The law was old, going back centuries to English common law, built on the pragmatic notion that land should not sit idle and disputed when someone is actually using it. In principle, it was reasonable. In practice, it was a weapon, and like any weapon, its morality depended entirely on the hands holding it. I went inside to get my keys. The Harlan County Courthouse was a 40-minute drive on roads I had known since I was old enough to ride in the front seat. The frost was burning off by the time I got there, the October sun doing its thin, flat work on the fields. I drove the way I always drive on these roads, not fast, not slow, the truck settling into the curves, with the ease of long familiarity. Brenda Oakes turned out to be younger than her voice, early 30s, dark-haired, with the efficient, slightly apologetic manner of someone who genuinely cared about doing her job well in a system that did not always make that easy. She had the filing ready when I walked in, slid across the counter in a manila folder, with the quiet competence of someone who had already done me a small kindness and did not need acknowledgement for it. "Is there a room I can use?" I asked. She pointed me to a small conference table near the window. I sat down, opened the folder, and began to read. Clifton had hired someone competent. That was the first thing I registered. The filing was structured correctly, the language was precise, and whoever had drafted it understood the elements. That told me something. This was not an impulsive move. This had been prepared, likely for some time, waiting for the right moment to surface. The claim asserted that Clifton Pruitt had openly and continuously occupied a portion of the eastern 40-acre tract, parcel 14A, for a period exceeding 10 years, meeting the statutory minimum under state law. He claimed to have maintained and improved the property during that period, establishing a hunting cabin and performing ongoing land management. He was petitioning for legal title to approximately 4 acres in the northeastern corner of the parcel, the section closest to Pruitt Creek. I read it again, slower. 30 years of reading legal documents had given me the ability to separate the architecture of a claim from its substance. The architecture here was sound. The substance was another question. Adverse possession requires 5 elements, and every one of them has to hold. Miss one, and the claim collapses. I went through them the way I always had, methodically, without rushing. The way my old professor at Morehouse used to say, you should read any legal document, assuming the other side is smarter than you until you have proven otherwise. The first element is actual use. The claimant must physically use the land, not just walk across it occasionally, but genuinely use it in the way that an owner would. A hunting cabin would support this. A man who runs a trap line or cuts firewood or maintains a fence line is doing something an owner does. I noted it as the strongest element in Clifton's filing. He had something physical to point to. The second element is open and notorious use. The occupation cannot be hidden. It has to be visible enough that a reasonable owner, paying attention, would know someone was using their land. A cabin is, by definition, visible. If the thing was sitting on that property for 10 years, and nobody from this family had said anything, Clifton's attorney would argue we had constructive notice, that we should have known. That was a problem I was going to need to look at closely. The third element is exclusive use. The claimant has to use the land as an owner would, not shared with the public, not in common with others. A private hunting cabin supports exclusivity. This element, on paper, probably held. The fourth element is hostile use, and here is where the word means something different than it sounds. Hostile, in adverse possession law, does not mean antagonistic. It means without the owner's permission. The use has to be against the interest of the true owner, not permitted by them. A license, a handshake agreement, a casual, sure, go ahead from the owner. Any of those things destroys hostility. If the owner gave permission, the use is permissive, and permissive use cannot ripen into title no matter how long it continues. I had spent half my career on this element. I had seen it save property and lose it. I underlined the hostility assertion in the filing and wrote nothing in the margin yet. The fifth element is continuous use for the statutory period. In this state, the claimant must demonstrate uninterrupted use for at least 10 years. Clifton was claiming 11. 11 years was enough? Barely, but only if the other elements held. Continuous did not mean constant presence, but it meant consistent use through the seasons, year after year, without abandonment. The filing offered general assertions about this, but thin specifics. No utility records, no dated photographs, no witness affidavits yet. Those could come later in discovery, but their absence from the initial filing was something I filed away. I closed the folder, thanked Brenda, and drove east. The eastern tract was a 40-minute walk from where I parked the truck at the field's edge. I had walked this land as a boy, hunting squirrels with my father, along Pruitt Creek in November, the leaves down, and the air smelling of cold mud and wood smoke. I knew this ground the way you know the face of someone you grew up beside, not always consciously, but in your body. The hunting cabin appeared where the land began to slope toward the creek. It was small, maybe 12 by 16, rough-cut lumber that had weathered to gray, a metal roof with one corner of flashing pulled loose. A length of firewood was stacked along the south wall, the pile not fresh, but not ancient either. A rusted propane tank sat on a concrete block to the left of the door. There was a wooden step in front of the entrance, new enough that the cut ends of the wood still showed some color. I circled it before I touched anything. The cabin sat roughly 30 feet inside the property line, deep enough to constitute actual occupation of the parcel, not a boundary straddle. That was deliberate positioning. Someone had done the math. I took photographs from every angle, methodical, overlapping, the way I had always documented disputed property conditions. I photographed the firewood. I photographed the propane tank. I photographed the new step wood against the weathered wall. Boards. I photographed the roof line and the pulled flashing and the single window on the east wall with its cracked glass pane held together by a strip of electrical tape. I noted the condition of everything, because condition tells a story. The tape on the window was brittle. The propane tank had surface rust consistent with years of outdoor exposure. The firewood pile showed weathering on the outer layer, but fresh split wood underneath. Someone had added to it recently. Within the last month, I would estimate. Within the last month, which was within weeks of my father's obituary. I wrote that in my phone's notes field. The interior, when I pushed the door open, smelled of old campfire and mouse droppings and the particular dampness of a structure that holds moisture without proper insulation. A folding cot, a camp stove on a plywood shelf, a plastic storage bin, lidded, 2 folding chairs, a calendar on the wall, 3 years old, still open to October, a buck photograph behind the dates. I did not open the storage bin. I did not touch the cot or the chairs. I photographed the calendar with the year visible. I was at the doorframe, about to step back outside, when I saw it. It was laminated, an index card sealed in the cheap, bubbled plastic of an old home laminator, tucked into the gap between the doorframe and the rough stud behind it. The kind of place you might put something you wanted to stay, but did not want obviously displayed. I worked it out carefully with 2 fingers, not disturbing the position more than necessary, and held it to the light. The handwriting was my father's. I had read my father's handwriting my entire life, on birthday cards, on checks, on the backs of envelopes he used for notes when he could not find paper. The looping capital C, the way he made his lowercase l with that small extra curve at the bottom. It was his hand, unmistakably. The note read, "Clifton, you can use the back corner for hunting season. Harold." The date at the top was 11 years ago, October. I stood there for a moment, in the gray light coming through the cracked window. 3 words. Use the back corner. Not own, not occupy. Use, the most permissive word in the English language when applied to land. My father had written permission into existence with the casual generosity of a man who never imagined it would be weaponized. He had no reason to imagine it. He was a farmer, not a lawyer, and he had extended a courtesy to a distant cousin, the way rural people extend courtesies, because that is what the geography demands. You share the creek, you share the road in winter, you let a man put a deer stand on your back 40 because you have known his grandfather and the land is big enough. Clifton had kept it, had laminated it, had hidden it in the doorframe of a cabin that had been sitting on my family's land for 11 years, waiting. He had done all of this knowing that permission destroys a hostile use claim. He had the note, and he had chosen not to make it public, which meant he either did not understand adverse possession law as well as his attorney, possible, or he intended to produce it under circumstances where I would not have time to respond. A surprise in litigation. A card held until the moment it cost me the most. Or, and this was the reading I kept returning to as I stood there, he had simply not thought through what the note meant for his own claim. Sometimes, people are strategic without being fully competent. They build a trap and do not notice they are standing in it. I photographed the note from 3 angles. I photographed the doorframe cavity it had been sitting in. I replaced it exactly as I had found it, same position, same depth, same angle, and stepped outside. The October light was going flat, the sun losing its brief warmth as it moved west of the creek tree line. I walked back through the eastern tract the way I had come, noting the fence line, noting where the old survey stakes should be and whether they remained. 2 of them were still there, rusted but legible, and I photographed those too. I called Franklin from the truck. Franklin Bates had spent 35 years in title insurance before his knees gave out, and he retired to a house near the lake with a bass boat and an opinion on everything. We had worked together on dozens of transactions over the years, him on the insurance side, me on the legal side, and there was no one alive who knew more about the quiet, grinding ways that rural land changed hands through legal mechanisms that most families never saw coming. Adverse possession, he said before I had finished explaining. How long has it been since Harold passed? 8 weeks. Yeah. He was quiet for a moment. I could hear the lake in the background. Water or wind over water. It is a pattern, Desmond. I have been watching it for 5-6 years now. These claims get filed against rural estates, almost always within the first few months after an elderly owner passes. The filing window, they call it. When the heirs are grieving, distracted, sorting out the will, nobody is walking the back 40, especially if the estate has multiple parcels and the heirs do not live locally. Targeting estates that cannot fight back. Targeting estates that will not know to fight back. There is a difference. An attorney now, that is a different proposition. He paused. Who is the claimant? Clifton Pruitt, second cousin, been gone 20 years. Pruitt? A beat. His family always had an eye on that creek land. His grandfather and your grandfather had words about the property line back in the 1950s, 60, somewhere in there. It is county record if you look for it. I had not known that. I wrote it in my phone. Franklin. If a claimant can demonstrate a written note from the landowner giving permission for use, what does that do to the hostile element? The pause before he answered told me he already understood the shape of what I had found. Destroys it, he said simply. Permission is fatal to hostility. If your father gave Pruitt permission to use that land, every day Pruitt spent on it was permissive use. You cannot convert permissive use into adverse possession by staying long enough. The clock does not run. That is my reading, too. You have got something. I have got a start, I said. I turned the truck toward home. The last of the afternoon light was orange on the frost-bleached fields. I will talk to you soon. I drove home thinking about my grandfather and about the particular patience required to clear 40 acres of hardwood by hand. The patience to work toward something that would not fully pay off in your own lifetime. The patience to do the work and trust that the people who came after you would know how to hold what you had built. That evening, I opened the family safe in my father's study, a heavy floor model that had been there since 1978, the combination written on the inside cover of a Bible on the shelf above it, because my father was a practical man. Inside was the original land survey from 1951, notarized and recorded. The deed, chain of title, running clean through every decade to the present. Property tax records going back to 1953, each parcel numbered, each payment documented. Parcel 14A, assessed and paid, without interruption, for 72 years. Clifton Pruitt had never paid $1 of tax on that land. Not one. I laid the documents on the desk and thought about the 5 elements again. Actual use. He had the cabin. Open and notorious. Arguable, given the cabin's visibility. Exclusive? Probably yes. Continuous for 10 years. Asserted but thin on evidence. And hostile? No. Not with that note in the doorframe. Not with my father's handwriting on an index card and a home laminator, granting permission in October of 11 years ago. The claim was a structure built on a cracked foundation. It looked solid from the road. Up close, with the right eyes, you could see exactly where it was going to fail. I straightened the documents, aligned their edges, and set them aside in the order I would need them. I was already building the case. I had been building it, in some form, since the moment I set down my coffee on the porch railing and heard my jaw tighten in the frost-quiet morning. Clifton Pruitt had made his move. Now I would make mine. The first neighbor I spoke to was Garland Fitch. Garland had farmed the property directly north of ours for 40 years. A man so rooted to his particular piece of Harlan County that I sometimes thought, if you pulled him up, you'd find his boots had grown into the clay. He was 73, walked with the careful deliberateness of someone whose hips had been arguing with him for years, and he knew every vehicle that had moved on every road within a mile of his fence line since approximately 1987. I drove to his place the morning after finding the cabin, before the day had fully committed to being cold, and found him in his equipment shed, doing something to a chain with a can of penetrating oil. Desmond. He set the chain down, wiped his hands on his overalls. Been meaning to come by since Harold passed. I'm sorry about your daddy. Thank you, Garland. He offered coffee. I took it. We stood inside the shed, where it was marginally warmer than outside, and I told him about the filing without any particular drama, the way you would discuss a problem with machinery. Here is what has happened. Here is what I need to know. He didn't look surprised. That was the first thing I noticed. The Pruitt boy, he said. The way he said boy made clear he was using the word the way older men use it about men who have misbehaved. Yeah, I've seen him out there, on and off, last 10, 12 years, hauling lumber in once, maybe twice. Brush clearing along the creek edge, couple of springs back. I figured Harold had him doing some work. Or maybe just let him hunt. You know how Harold was about family. Did anyone ever question it? Call Harold about it? Garland looked at me with the patient expression of a man who finds a certain category of question naive. Desmond, half the families in this county have some arrangement or another with somebody about some piece of land. Mineral rights, grazing rights, cutting wood off the back end. People don't always paper it. Harold never said anything. Pruitt never caused trouble. We figured it was a family arrangement. There it was, the invisible architecture of rural assumption, the system of informal permission and unspoken agreement that functioned perfectly well until someone decided to use it as a legal weapon. Clifton had understood that system. He had hidden inside it deliberately, letting neighbor after neighbor draw the same comfortable conclusion. Garland, I need to ask you something, and I need your honest answer. I set my coffee down on the workbench. If I were to bring a written statement to you, something formal, a notarized affidavit, would you be willing to put down in writing what you've told me, what you saw, and when, and what you assumed? He looked at me for a moment. You're building a case. I'm protecting the estate. Same thing. He picked up the chain again, then set it down. Yes, I'll sign whatever you need. Harold was a good man, and I knew his daddy before him. I'm not going to let some courthouse filing take 40 acres of Achebe-Wilder land without saying what I know. I drove to 3 more neighbors that week. 2 of them had seen Clifton on the property. All of them had assumed the same thing. Family arrangement, Harold's permission, no cause for concern. None of them had any reason to believe otherwise. I took written statements from all 4, formal enough to hold weight, recording specifically what each person had observed and when, dates, activities, vehicles. Together, the statements began to construct a timeline and a picture of Clifton's method that was starting to look less like opportunism and more like patient planning. I had started to suspect there was a pattern. I drove to the county records office the following Tuesday to confirm it. The adjacent county's public records were accessible through the state's unified land system, a digitization effort from a decade back that had been underfunded and therefore incomplete, but functional enough for my purposes. It took me 2 hours and some assistance from a board records clerk named Dale to find what I was looking for. 6 years ago, in Callaway County, a man named Clifton R. Pruitt had filed an adverse possession claim against a 12-acre parcel belonging to the estate of one Marvella Hutchins, deceased, whose obituary had appeared in the Callaway County Register approximately 5 weeks before the filing. The claim had been settled out of court 11 months later. The settlement terms were sealed, but the filing was public, and the shape of it was familiar. The hunting use assertion, the claimed improvements, the precise 10-year occupation, period stated, as if measured by stopwatch. I read it twice. I sat back in the chair and looked at the water stain on the ceiling of the county records room. Marvella Hutchins, an elderly widow with a rural estate and, presumably, heirs who were either distant, disorganized, or simply unprepared for what adverse possession actually meant in practice. Someone had paid Clifton to go away. $85,000 perhaps. Perhaps more. In exchange for dropping a claim that might or might not have held up in court, but that had cost the estate legal fees, emotional strain, and ultimately a check. That was the business. Not desperation, strategy, target the estate when it was weakest, file before anyone thought to look at the back 40. Let the legal process do its slow grinding work until the heirs simply got tired and paid. I wrote Marvella Hutchins' name in my phone And then I called Franklin. "I know about the Hutchins case," he said, before I finished the sentence. "I was wondering when you'd find it." "You knew?" "I suspected. When you told me the name Pruitt, I ran it. The Callaway filing is the only one I found. But Desmond," he paused, "that doesn't mean it's the only one. Just the only one that made it to filing. If the others were settled with a letter and a check before any paperwork hit the courthouse, there'd be no public record." I sat with that for a moment. The weight of it. A man who had made a practice of this, who had spent years identifying vulnerable estates, establishing footholds years in advance, and then filing at precisely the moment when the family was least capable of responding. Grief is a powerful disorganizer. I had seen it in my own practice, watched families fail to act on time-sensitive matters because the machinery of loss had slowed everything down. "Franklin," I said, "I need to know everything Callaway County has on that settlement. Whatever's public." "Already pulled it," he said. "I'll email it to you tonight." I drove to the county seat the next morning to see Vera Stanton. I want to be clear about why I went. It was not because I needed Vera to explain property law to me. I had practiced it for 3 decades. It was because a man who represents himself has a fool for a client, and because the kind of adversary I was now building a case against deserved more than one set of eyes. Vera had 15 years of property litigation experience and a particular gift for anticipating how a judge would read a filing. I needed her for the courtroom architecture, and I needed her as a witness to my own evidence, so that if Clifton's attorney later tried to claim I had manufactured documentation, there was another professional who had held the originals. Vera Stanton's office was on the 2nd floor of a building that had been a grain exchange in a previous century, with tall windows and wide plank floors that tilted slightly toward the east. She was 51, compact and precise. With reading glasses she took on and off with the focused impatience of someone who resented needing them. She had represented farming families in this county long enough to have opinions about most of the land disputes that had moved through the courthouse in the last decade, and she expressed those opinions with an economy of words that I respected. We spent 2 hours at her conference table. I laid out the filing first, the way I would with a client. Organized, chronological, no editorial. Let the documents tell the story. She read Clifton's adverse possession claim with her glasses on, making no comment until she reached the last page. "He's got a competent attorney," she said. "The structure is right. Elements are at least asserted for all 5 prongs. The cabin is what he's hanging actual use on. Tell me about the cabin." I described it. The dimensions, the materials, the condition of each element, the propane tank, the firewood pile, the 3-year-old calendar, the new stepwood against old wallboards. I watched her face as I talked. She had the particular expression of someone running calculations. "No foundation?" she said. "Skids. It's sitting on timber skids." She took her glasses off. "That's going to be a problem for him." Courts in this state have been consistent about the distinction between permanent improvement and temporary structure. A cabin on skids is movable, and movable matters, because actual possession under adverse possession doctrine requires you to treat the land as an owner would. Owners build permanent structures. A hunting cabin on timber skids that has a cracked window and a propane tank you could disconnect in 20 minutes is not an owner's improvement. It's a camper. His attorney will argue the firewood, the brush clearing, the maintenance. Maintenance of what? A shed? She leaned back. "Look, Desmond, I'm not saying he can't make arguments. I'm saying the actual and notorious elements have real vulnerability. But that's not your strongest ground." She looked at me steadily. "What else do you have?" I slid my phone across the table with the photograph on the screen. She read it again, set the phone down, picked it up, and read it one more time. "Clifton, you can use the back corner for hunting season," she said. "Harold's handwriting?" "Unmistakably. I've got 100 samples for comparison if it comes to that. Birthday cards, letters, deed signatures. It's his hand. Dated 11 years ago, October, just before hunting season would open." Vera set the phone down slowly and looked at me over the table. "Where was this?" "Behind the door frame of the cabin, laminated, hidden, but not destroyed. He kept it." She was quiet for a moment. The building settled around us, the old grain exchange floor doing its slow architectural complaint. When she spoke, her voice was level, but I could hear something underneath it. The particular satisfaction of a litigator who has just watched a trap spring. "Clifton just gave you the case," she said. "We talked through the law of permissive use for another 20 minutes. Vera explained what I already knew, but needed articulated clearly for the record. That permission, once granted, transforms the entire nature of the occupation. A man who uses land with the owner's consent is not a hostile possessor. He is a licensee, and a license cannot ripen into title, regardless of how many years pass, because the clock on adverse possession only runs against a hostile use. The moment Harold put pen to paper and wrote Clifton, you can use the back corner. Every day Clifton spent on that land became permissive. The hostile element didn't merely weaken, it evaporated. Here's what makes it interesting," Vera said. "Clifton kept the note. He laminated it and tucked it in the doorframe. Why? He was going to produce it, right, but on his terms. Either as a setup for a different narrative, Harold gave me permission verbally, and here's a contemporaneous written record of that conversation, or as a bargaining chip in settlement. Back off on the hostile element argument, and I won't pursue the claim that Harold verbally promised me the land. He didn't anticipate that the note destroys his own claim. He may not have fully understood the law, or his attorney is newer to adverse possession than the filing suggests." She paused. "Either way, it doesn't matter now. You have it. The question is when and how you use it." "Not until deposition," I said. She nodded once. "Not until deposition." I drove home and began the process of quietly assembling everything into a single binder, the kind of organizational structure I had used in litigation for 30 years, built for a judge's eyes and opposing counsel's discomfort. The original land survey, the full chain of deed title back to 1951, tax payment records for every parcel, including 14A, without a single year's gap, the 4 neighbor affidavits, notarized, the Callaway County filing on the Hutchins estate, public record, printed and tabbed, the cabin photographs, time-stamped, in sequence, the photograph of the note, and a property appraiser's assessment of the cabin's structural classification. I had called a certified appraiser I'd worked with for years, explained what I needed, and he had done a written evaluation based on my photographs and description that characterized the structure as a temporary seasonal shelter with no fixed foundation. I was on page 63 of the binder when Clifton called. The number came up as unknown but local, and I had been expecting it. I answered and put the phone on speaker so my recorder could pick up the audio cleanly. One-party consent in this state. I was the party, and I was consenting. Desmond, his voice, was the voice of a man performing reasonableness, controlled warmth, with something underneath it that was neither. I hadn't heard it in 20 years, and it was both familiar and strange, like a piece of furniture you remember from childhood appearing in the wrong house. I was hoping we could talk before this gets any further down the road. "Go ahead," I said. Your daddy promised me that land, Desmond. You know that. That corner by the creek. Harold and I had an understanding going back years. I put 12 years of my life into that corner, cleaned it up, built a place, kept it from going to brush. You know what's right. I said nothing. I had learned 30 years ago that silence in a conversation draws out more than questions do. People fill silence with whatever they most want to say, which is usually what they most want to hide. I don't have any quarrel with you personally, he continued, with slightly less warmth now. This is about honoring what Harold wanted. That's all. The man's barely in the ground, and here we are in a courthouse dispute over something he would have just handled between family. I thought about the laminated note in the doorframe, about the Hutchins estate in Callaway County, about the word family, the way he deployed it like a tool. I'll let the process work, I said. It was the first sentence I had spoken. A pause. The process is going to cost both of us money and time. It might, I agreed. Another pause. Longer. All right, he said, and the warmth was mostly gone now. All right, Desmond. He ended the call. I played the recording back once, confirmed the audio quality, saved it to 2 separate locations. Clifton had said your daddy promised me that land. He had not said your daddy gave me a written note permitting seasonal hunting use. He had escalated his claim from what the note actually said to what he wished it had said. That escalation was on tape, in his voice, with a timestamp. The motion to expedite arrived 4 days later, filed by Clifton's attorney, a man named G. Warren Aldy, based in the county seat, who had a clean website and a practice that appeared to include a reasonable mix of real estate and civil matters. The motion cited irreparable harm to Clifton's alleged improvements, arguing that without expedited resolution, the claimant risked losing the benefit of his 11 years of investment in the property. It was a pressure move designed to create urgency and force the estate into either settling or appearing disorganized at a rushed hearing. I read it with my first cup of morning coffee and set it aside. The same week, my neighbor Dorothy Alcott called in a state of mild alarm. Dorothy was 70, sharp as a finishing nail, and farmed a 20-acre property to the south of ours that had been in her family nearly as long as ours had been in mine. Desmond, she said, a man called me yesterday asking questions about Harold, about whether Harold ever talked to him about the east parcel. I didn't know what to tell him. What did you say? I said I didn't know anything about any arrangement Harold had with anyone, which is the truth. But Desmond, the way he was talking, he was trying to get me to say that Harold would have wanted him to have that land. That's not a question. That's a leading statement with a question mark attached. Did you say anything that could be interpreted that way? Desmond Achebe-Wilder. I have been talking to men who want something from me since 1973. I said I couldn't speak to what Harold would have wanted, and that I had nothing further to add. A pause. But I want you to know what's happening. I do know. Thank you, Dorothy. Is there anything I can do? Your statement, I said, the one you gave me last week. It's exactly what's needed. The settlement letter from G. Warren Aldy arrived by certified mail on a Thursday, $85,000, in exchange for a deed transfer of the eastern 40-acre tract, parcel 14A, to Clifton R. Pruitt. The letter characterized the offer as generous, given the strength of the adverse possession filing, and suggested that protracted litigation would cost the estate considerably more than the difference between the offer and the parcel's assessed value. I read the number twice. $85,000 for 40 acres that comprised a meaningful portion of a $750,000 estate. land my grandfather had cleared by hand, that my father had taxed and tended and left to me to protect. I thought about the Hutchins estate, about the widow who had written a check and made Clifton go away. I filed the settlement letter in the binder behind Clifton's prior Callaway County filing, which I thought was the appropriate place for it. I did not respond. The notice in the county paper appeared the following week. A brief public notice of pending adverse possession litigation as required by law. Routine, 2 column inches, the kind of thing most people skim past. But in a county where people had known my family for 3 generations, 2 column inches was enough. I got 3 calls that week from people I hadn't spoken to in years. Most of them were supportive. One of them was a second cousin on my mother's side, who wanted to know if she should be worried about her own property and whether Clifton might try the same thing elsewhere. The reputational pressure was real. In a rural county, a courthouse dispute is a social event. People would form opinions. People would talk. Clifton knew this, and I believe the newspaper notice, while technically required, had been timed deliberately. I let it run. I didn't call the paper. I didn't explain myself to anyone who hadn't asked directly. I continued building the binder. The deposition was scheduled for 11 days after the motion to expedite was filed. G. Warren Aldi deposed me in a conference room at his office, with a court reporter and Vera Stanton sitting beside me. Clifton was present, seated across the table. He was heavy-set and pink-faced, a man in his mid-60s, who carried himself with the slightly injured dignity of someone who had spent decades believing the world owed him an adjustment. He looked at the binder when I set it on the table. I watched his eyes move to it, and then away, as if looking directly at it required effort. Aldi was practiced and professional. He walked me through the family history methodically, establishing the relationship between my father and Clifton, the nature of the property, the family's use of the Eastern Tract over the decades. He was building context, trying to establish a narrative of family understanding and informal arrangement that would give Clifton's claim emotional texture, even if its legal structure was thin. Then, he arrived at the question he had been building toward. Mr. Achebe-Wilder, isn't it true that your father, Harold Achebe-Wilder, maintained a close relationship with Mr. Pruitt over the years, and that he may have verbally expressed his intention that Mr. Pruitt have access to and use of the Eastern Tract? I looked at him for a moment. The room was quiet, except for the soft percussion of the court reporter's fingers. He granted permission in writing, I said. I have it. The room changed. It was not a dramatic change. No one stood up. No one said anything. But something shifted in the quality of the air, the way air changes in a barn when weather is coming. Aldi went very still. Vera, beside me, did not move. Clifton, across the table, looked at the binder. I opened it to the tabbed section and slid the enlarged printed photograph of my father's note across the table. Harold's handwriting, clear as the day it was written. Clifton, you can use the back corner for hunting season. Harold, and the date, 11 years ago. Aldi picked it up, read it, set it down, picked it up again. Clifton was staring at it with the expression of a man watching a hand he believed he was holding turn into something different. He knew what it meant. In that moment, I was certain of it. He had known, on some level, exactly what that note meant for his claim. He had kept it because he intended to use it, and he had hidden it because he didn't want it found too soon, and he had never fully resolved the contradiction between those two intentions, which told me that the sophistication of his scheme had a ceiling. He understood the tactic. He had not fully understood the law. This document, Aldi said carefully, indicates a conversation between Mr. Pruitt and the deceased regarding use of the property. It indicates written permission for seasonal hunting use, I said, specific in scope, granted by the owner, which establishes, as a matter of law, that Mr. Pruitt's occupation of the Eastern Tract was permissive from the outset. Permissive use cannot form the basis of an adverse possession claim, regardless of its duration. The hostile element of the five-part test does not exist in this case. It never existed. Vera touched my arm lightly, her signal that I had said enough. I stopped. Aldi looked at Clifton. The look was brief, professional, and contained within it the particular communication that passes between an attorney and a client when the landscape has just changed. The deposition continued for another 40 minutes, but its center of gravity had shifted. Every question Aldi asked after that photograph crossed the table was a holding action, buying time to think. I answered everything precisely and completely, volunteering nothing, the way you do when the evidence is already doing the heavy lifting. When it was over, Vera and I walked out into the October afternoon together. The light was the same flat gold it had been the morning I found the cabin, the light of a season that has made its peace with ending. He'll look for a way to reframe the permission argument, Vera said. Say it was a conversation, not a formal grant. Say the note was taken out of context. He laminated it and hid it in a door frame, I said. 11 years ago. A note he wrote himself, in the claimant's own cabin, on the claimant's allegedly adverse possessed land. Vera was quiet for a moment. Yeah, she said, that's going to be a hard story to tell to a judge. I drove home in the late afternoon, the fields going amber on either side of the county road, the air carrying the first real bite of what was coming. The hearing was tomorrow. I had done everything I could do. The binder was complete, the arguments were mapped, the evidence was organized in the sequence that would tell the clearest story to someone seeing it for the first time. I was on the porch in the dark when I heard the truck. It came up the gravel drive slowly, the headlights washing across the front of the house before it stopped. Clifton got out. He walked to the porch steps and stopped there, looking up at me with his hands in his jacket pockets, his face in the shadow of the porch light. He leaned against the railing. There was something in his posture that wanted to look casual and didn't quite make it. You've been gone for 30 years, Desmond, he said. You don't even know what this land is anymore. You're just a name on a deed. I had the screen door half open. I stood there and looked at him for what felt like a long time. I thought about my grandfather with his axe and his sons and 3 summers of limestone. I thought about 72 years of tax receipts, every one of them paid on time. I thought about the laminated note in the door frame and the Hutchins widow in Callaway County and the phone recording where Clifton said your daddy promised me that land. Then you should have read the deed more carefully, I said. I closed the door. Inside, the farmhouse was quiet around me. The particular quiet of old wood and old land and a family that had held something long enough for the holding to become part of what they were. I sat at the desk in my father's study, opened the binder, and read through the filing one final time. Everything was in order. It had always been in order. Clifton had built his case on the assumption that no one would look closely, that the land would yield because the family had grown distant, that Harold's death had left a gap that could be stepped into quietly and claimed. He had been wrong about all of it. I closed the binder at 11 o'clock and went to bed. Tomorrow was going to be a long day, and I wanted to be rested. I wore my father's tie to the hearing. It was a plain thing, dark blue wool, slightly narrow by current standards. The kind of tie a man buys once and keeps for 30 years, because it does what a tie is supposed to do without making any particular claim about itself. I had found it in the closet of his study, hanging with 3 others on a wooden rack he had built himself from a piece of walnut salvaged from the creek bank. I stood in front of the mirror in the farmhouse bedroom at 6 in the morning and tied it with the same half Windsor I had been tying since law school. And I thought about how many times my father had stood in front of this same mirror, in this same light, getting ready for something that mattered. The Harlan County Circuit Court was a 40-minute drive I had made in 25 minutes in my early years as an attorney, back when urgency felt like its own form of preparation. I drove it in 40 now, the way I drove everything since I had come home, at the pace the county roads suggested, rather than the pace my ambitions demanded. The October fields went by in the thin early light, frost on the stubble, a heron standing motionless at the edge of a drainage ditch, as if it had been posed there by someone who understood the value of stillness. Vera was waiting on the courthouse steps with her briefcase and 2 cups of coffee. She handed me one without comment. "Aldi filed a supplemental brief last night," she said. "He's trying to reframe the note as a verbal agreement reduced to informal writing rather than a formal permission grant. He's arguing it demonstrates Harold's intent to support Clifton's use rather than limit it. That's a reach. It's a desperate reach, yes." She pushed the door open. "But it tells us they've been up since midnight thinking about what we're going to do to them." The courtroom was smaller than the ones I had spent most of my career in. A county courtroom with wooden benches worn smooth by decades of use. Tall windows that let in the kind of light that is neither flattering nor harsh, simply honest. Judge Harlan Mabry had presided over land disputes in this county for 22 years, which meant he had seen every variation of neighbor conflict, boundary encroachment, and title claim that rural property law could produce. He was in his late 60s, deliberate in his movements, with the particular judicial patience of a man who has learned that most cases reveal themselves if you give them sufficient room to do so. I sat at the defense table and opened my binder. Clifton was at the plaintiff's table with G. Warren Aldi, both of them in suits that were slightly too formal for a county circuit courtroom. Clifton looked at me once when I sat down. I did not return the look. I was reading my own notes, and my notes were more important. Aldi presented first. He was polished and organized. I will grant him that. He walked the court through the adverse possession claim with the rehearsed confidence of someone who had presented similar arguments before and had reason to believe they worked. 12 years of continuous occupation, a visible structure built in good faith, improvements made at personal expense. And then he did something I had not anticipated, but perhaps should have. He invoked the language of family. He spoke of Harold Achebe-Wilder's spiritual promise to a blood relative. He spoke of rural tradition and the informal arrangements that held agricultural communities together. He spoke of Clifton's years of labor and investment, of the injustice of an heir returning from absence to claim what a dying man had already given. It was well-constructed theater. I watched Judge Mabry's face while Aldi spoke. The judge's expression gave nothing away, but his pen moved occasionally. Quick, precise notations. The marks of a man tracking specific claims against specific standards. When Aldi finished, Mabry looked at our table. "Ms. Stanton." Vera stood. She was not theatrical. That was one of the things I valued most about her in a courtroom. She understood that evidence, properly organized, was its own form of argument. She did not need to dress it up. She presented the exhibits in the order we had discussed, each one introduced with a precise, minimal statement of what it was and why it mattered. Exhibit A was the photograph of Harold's handwritten note. enlarged to 8 by 10, mounted on board. Clifton, you can use the back corner for hunting season. Harold, the date was 11 years ago. Your Honor, Vera said, this document was found inside the structure on parcel 14A, hidden behind the doorframe. It is in the handwriting of Harold Achebe-Wilder, confirmed by 3 independent handwriting samples from the same period. It demonstrates that the claimant's occupation of the Eastern Tract was expressly permitted by the property owner. Under well-established law, permissive use cannot form the basis of an adverse possession claim. The hostile element, which must be proven by the claimant, not merely asserted, does not exist in this case, and has never existed. Exhibit B was the audio recording of Clifton's phone call. Vera played the relevant portion through a small speaker, and Clifton's voice filled the courtroom with its practiced reasonableness. Your daddy promised me that land, Desmond. I put 12 years of my life into that corner. You know what's right. The word promised, said clearly, in Clifton's own voice, with the timestamp of a call made to the estate heir during active litigation. Permission acknowledged. Hostility negated. Mabry wrote something. Exhibit C was the adverse possession filing from Callaway County, 6 years prior. The Hutchins estate. Vera did not editorialize. She simply submitted it as a matter of public record, noted the structural similarity to the current filing, and let the court draw its own inference about pattern and premeditation. Exhibit D was the property tax record, 71 years of unbroken payment on parcel 14A, every year documented the Achebe-Wilder family's continuous legal ownership of the land, expressed in the most concrete language the state recognized. Exhibit E was the licensed surveyor's report, submitted by the certified appraiser I had called in the first week. The cabin, it confirmed, sat 14 feet inside the legal boundary of the Achebe-Wilder property. Not on the boundary, not straddling it, but squarely, unambiguously, within the estate's recorded land. The boundary markers confirmed it. The GPS coordinates confirmed it. The 1951 survey confirmed it. Vera sat down. Aldi attempted a rebuttal on the note. Precisely the argument he had foreshadowed in his supplemental brief, framing Harold's permission as evidence of broader intent rather than limited license. The argument required the court to believe that a man who wrote you can use the back corner for hunting season had actually meant something considerably larger and more permanent than those words said. Mabry listened to it with the same still patience he brought to everything. When Aldi finished, the judge was quiet for a moment. I've heard this case, he said. He did not sound like a man who needed more time. He set down his pen and looked at the room over his reading glasses with the expression of someone who has something specific and useful to say. The law of adverse possession exists for a reason, he began. When land sits genuinely abandoned, when the true owner has made no use of it and shows no interest in it, the law recognizes that someone who has occupied, improved, and maintained that land for the required statutory period may have a legitimate claim to title. That is the doctrine as originally conceived, and it remains valid law in this state. He paused. Clifton, across the aisle, was very still. But the doctrine has requirements, Mabry continued, and those requirements are not suggestions. They are the structure of the claim itself. Remove any one of them, and there is no claim. Not a weak claim, not a partial claim, but no claim at all. The claimant must demonstrate actual use, open and notorious use, exclusive use, continuous use for the statutory period, and, critically, hostile use. Hostile meaning without the permission of the true owner. He picked up the photograph of Harold's note and looked at it for a moment. This court finds that the hostile element of the adverse possession claim in this matter is fatally defeated. The written note, in the hand of the late Harold Achebe-Wilder, demonstrates that the claimant's occupation of the disputed parcel was expressly permitted. Permissive use, however long continued, cannot ripen into title. The claimant's own recorded statement, in which he characterizes his occupation as the result of a promise from the property owner, further confirms that he understood his presence on the land to be permission-based, not independent of the owner's consent. He set the photograph down. The claim is dismissed with prejudice. Dismissed with prejudice. The words that meant Clifton could not refile on the same grounds. Not this year, not in 10 years, not ever. The claim was not merely lost, it was permanently extinguished. The claimant is ordered to remove the structure from Parcel 14A within 60 days at his own expense, and to restore the land to its condition prior to the structure's placement. Failure to comply within 60 days will result in a daily fine accruing to the estate, and the estate will have the right to remove the structure and recover costs from the claimant directly. Mabry looked up one final time, then closed his folder. Clifton stood. His attorney was already gathering papers with the focused efficiency of a man redirecting his attention to the billing statement. I watched Clifton move toward the aisle, his face set in the expression of someone who has not yet decided what the next performance will be. Whether it will be wounded dignity, or simmering grievance, or something else entirely. I had not spoken in that courtroom except to answer questions. I had sat beside Vera and let the evidence do its work, the way I had counseled clients to do for 30 years. But as Clifton reached the aisle, I spoke. Clifton. He stopped, looked at me. My grandfather built that farm with borrowed tools and borrowed time, I said. Every inch of it is documented. You picked the wrong family. He said nothing. His attorney was already looking at his phone. Clifton walked out. The courtroom doors swung closed behind him, with the ordinary sound of a thing that is finished. Vera put her hand briefly on my arm. I nodded. Outside the tall windows, Harlan County went about its morning. The quiet title action was filed the following week. Vera handled the paperwork, but I had drafted the underlying argument myself, partly because I trusted my own draftsmanship on title matters, and partly because writing it was its own form of closure. A quiet title action is a legal proceeding designed to do exactly what its name suggests, to silence any competing claim to a property and establish the owner's title as clear and uncontested on the public record. Where an adverse possession dismissal removes the specific claim, a quiet title order removes the cloud, the legal shadow that any filed claim, even a dismissed one, casts over a deed. Future buyers, future lenders, future heirs would see a clean title with no asterisks, no pending matters, no history requiring explanation. The court granted it without a hearing. There was nothing to argue. 2 weeks after the quiet title order was recorded, I drove to the county line and met with a licensed surveyor named James Coe, who had done work for farming families in Harlan County for 25 years. We walked the full boundary of the eastern tract together, all 40 acres, the creek side and the ridge side, and the long fence line to the north. James set permanent boundary markers at each corner, galvanized steel posts driven 18 inches into the ground, color-coded flagging, GPS verified coordinates. He filed a certified plat with the county recorder's office that afternoon. The boundary of the Achebe-Wilder Eastern Tract was now a matter of permanent, documented public record, indisputable by any future claimant who cared to look. The family land trust took longer to establish, but I had been thinking about it since the second day of this whole proceeding, when I understood fully what Clifton had done and how simply it had been accomplished. He had identified a property with aging ownership and estimated disorganized heirs. He had been right about the aging ownership and wrong about everything else. But he would not always be wrong about the heirs. The estate would pass again someday, and I would not always be there to walk the eastern tract at sunrise and find laminated notes in door frames. The trust I established placed the entire Achebe-Wilder estate, all 7 parcels, including the eastern 40 acres, under a single legal entity with documented governance. Any permission granted to a third party for use of trust land would require written documentation, filed with the trust records. Any future adverse possession claim would face not a single grieving heir, but an institutional entity with standing, continuous documentation, and a defined process for response. The trust also required annual property inspections, a formal walk of every parcel, documented in writing, a record of presence and ownership that would continuously reset the clock against any future claim of abandonment. I named Vera as the trust's designated legal advisor, and Franklin as a non-voting trustee with specific authority over title insurance matters. The people who had helped me hold the land would help those who came after me hold it too. 3 months after the hearing, on a morning that carried the first real bite of winter still weeks away, but clearly coming, I drove to the eastern tract at first light. The cabin was gone. Clifton had removed it in the 5th week, close enough to the deadline to make a point, I supposed, though what point exactly, I could not determine. The skids were gone too, dragged out through the field, leaving 2 pale parallel scars in the ground where the timber had sat. There was a depression where the concrete block had held the propane tank. The firewood was gone, the step wood, the rusted flashing, and the cracked window, and the 3-year-old calendar with its buck photograph. The land was not clean yet. That would take a season or 2, the ground healing itself the way ground does when it is left alone and has good memory. But it was present. It was itself again, the northeastern corner of the eastern 40 acres, with Pruitt Creek audible through the bare trees and the frost on the dead grass catching the first horizontal light of the morning. I had brought a tree spade and a 5-gallon bucket and a bur oak sapling that I had grown from an acorn in a pot on the farmhouse porch. The acorn had come from the tree line at the south edge of the property, the same trees my grandfather had planted to stabilize the creek bank in 1953, oaks that were now 60 feet tall and wide enough that it took 2 people with linked hands to encircle them. I dug the hole where the concrete block had been, at the precise spot the propane tank had sat. I settled the root ball into the ground, tamped the soil around it, and poured the bucket of water slowly, watching it darken the earth. The sapling was about 18 inches tall, a modest thing, with the particular look of something that has not yet decided how large it intends to become. It would be 40 years before it was much to look at. I found that neither discouraging nor particularly poignant. It was simply true. The same way it was true that my grandfather had not lived to see his creek bank oaks reach their full height, and had planted them anyway. I stood at the eastern fence line as the sun cleared the ridge, and the cold light came across the 40 acres in a long, even wash that turned the frost briefly gold before burning it off. I had the quiet title order folded in the inside pocket of my jacket, against my father's tie that I had worn again this morning. For no reason I could have articulated, that would have satisfied a lawyer. Clifton had never understood what he was looking at when he looked at this land. He had seen a dollar value and an unguarded asset, and the opportunity that grief creates in families that do not know what they are holding. He had filed his claim within weeks of my father's obituary because he believed that the land's protector was gone and the land was therefore undefended. What he had not understood, what I had spent the last 3 months demonstrating in courtrooms and county offices and on surveyed ground, was that the land's most powerful defense was never a single person. It was a pattern, 71 years of tax receipts, a deed that traced back to a man with an axe and borrowed time, neighbors who had watched and remembered, documents in a steel box under the floorboards, organized by year, going back to 1951. The most powerful document in any land dispute is not the deed itself. It is the unbroken record of presence, the accumulated evidence that this ground has been tended, paid for, walked, and known by the same family across generations, without gap or abandonment, in every season of every year that the law requires you to prove. Clifton had tried to manufacture that record in 11 years. My family had built it across 7 decades. There was no version of that contest he was ever going to win. I turned and walked back toward the farmhouse. The bur oak sapling stood in the cold light behind me, its bare branches holding the morning, like a claim that had just been planted. There was still work to do before winter,